You can spend your whole life following gun laws and still miss the rights you still have after 60, 70, or even 80. Pause. And if you believe the myths, you could give up freedom that federal law never took from you in the first place. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal could keep you from making a mistake that costs you your guns, your money, or even your clean record. Hit that subscribe button right now and stay with me to the end, because the fifth right is the one that shocks most families when mom or dad moves into senior housing. First thing you need to know is this. There's no federal rule that says you age out of your gun rights. Let that sink in. A lot of people act like once you hit a certain birthday, your rights get weaker. That is not how the main federal law is written. Federal law in 18 U.S.C. 922 talks about minimum ages for some sales, like handguns from licensed dealers to people under 21, and firearms or ammo to people under 18. But it does not create a maximum age, and when ATF lists prohibited persons, being old is not on that list. Source. Now this is where it gets interesting. Most people think turning 70 or 80 puts you under some special gun suspicion. But the truth is much narrower. Federal law looks at specific legal triggers, things like certain felony convictions, certain domestic violence convictions, unlawful drug use, some restraining orders, or being adjudicated as mentally defective or committed to a mental institution. That means your age alone is not the issue. Your birthday is not the problem. The legal record is the problem. That difference matters more than most people realize. Source. Here's a hypothetical example to explain this. Imagine Frank is 78. He still hunts every fall. He stores his rifle safely. He has no disqualifying record. He hears a guy at the diner say, "Once you hit a certain age, the government can take your guns." Frank gets scared. He gives his rifle to a nephew for no reason. That happens more than you think. But under federal law, Frank did not lose his rights just because he got older. What he lost was confidence, and bad information caused it. That is why this first right matters so much. Don't surrender rights you still legally have. But wait, there's something even more important. A health scare or memory concern is not the same thing as an automatic federal gun ban. That does not mean families should ignore warning signs. They should not. Safety matters. But people often blur together aging, illness, and legal disqualification as if they are all the same. They are not. Here is what most people get wrong. Decline may create serious family safety decisions. But federal disqualification usually turns on formal legal findings. Not gossip, not age, and not fear alone. That is a huge difference, and seniors need to know it before they let somebody bully them into giving everything up. Source. Second, receiving Social Security or retirement benefits does not automatically kill your gun rights. This one fooled a lot of people. You may remember hearing that older Americans would be dumped into the background check system just because they needed help with money. That story spread like wildfire. But here's the part nobody talks about. The Social Security rule that got so much attention was much narrower than the rumors made it sound, and it did not apply to ordinary retirement benefits. Fact Check explained that the rule targeted a limited group of disability beneficiaries ages 18 to full retirement age, who met strict criteria, including severe mental impairment findings and having a representative payee. It was later repealed. Source. Let me break this down for you in plain English. If you're getting Social Security retirement, that alone does not make you a prohibited person. If your daughter helps you balance the checkbook, that alone does not make you a prohibited person. If you need help paying bills, that alone does not make you a prohibited person. That old rumor scared many seniors into thinking normal aging and normal financial help were enough to end their rights. They were not. Source. Now, don't make this mistake. Don't swing too far the other way and think nothing can affect your status. If a court or another lawful authority makes a formal mental health finding, or if state law adds reporting rules tied to guardianship or commitment, then the analysis changes fast. That is why details matter. Words on legal paper matter. The source of the finding matters. Your state matters. So the forgotten right here is not nothing can ever happen. The real right is that benefit status by itself is not the same as a federal ban, and that could save a family from panic, bad transfers, and bad advice. Source. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that can protect you when police ask about your gun. Subscribe so you don't miss it. I make these videos to save you time, stress, and very expensive mistakes. Third, you still have the right to pass lawful firearms down to your heirs, and federal law even includes an inheritance exception that surprises a lot of families. Here's what just happened in countless homes across America. Grandpa dies, the family finds an old deer rifle, a shotgun, maybe a revolver in the closet. Everybody freezes. They think, we can't touch this. We can't move it. If the heir lives in another state, this is impossible. But federal law is more specific than that fear. In 18 U.S.C. 922, there are exceptions for firearms received by bequest or intestate succession. That means guns passed through a will or through inheritance. When there is no will, can sometimes move across state lines under that exception if the heir can lawfully possess them in the home state. Source. That sounds simple, but here's the crazy part. Families mess this up because they treat every transfer the same. They assume a gift, a sale, and an inheritance all work alike. They do not. A normal across-state transfer usually has different rules. An inheritance can fall under a specific exception in the federal statute. So imagine this. A father in one state leaves a hunting rifle to his daughter in another state. The family may have a lawful path because it is an inheritance, not just a casual handoff. That is a big deal, especially for seniors trying to do estate planning the right way. Source. But here's the warning nobody wants to hear. State law still matters. And NFA items are a whole different animal. If the firearm is an NFA item, like certain short-barreled rifles or suppressors, ATF says estate transfers require special handling. Lawful heirs may receive registered NFA firearms tax-free through the estate, but the executor must file Form 5 and get ATF approval before distribution. ATF also warns that unregistered NFA firearms are contraband and cannot be lawfully transferred. So yes, the inheritance right is real, but sloppy handling can turn a family keepsake into a legal nightmare. Source. This is why smart seniors do something most people avoid. They plan early. They write down what they own. They think about who can lawfully receive it. They talk to a trusted attorney if the collection is large or unusual. Most people think estate planning is about money and land. But if firearms are involved, that plan can protect both your family history and your family from trouble. Fourth, if your rights are challenged, you may still have the right to a hearing. And in some situations, there may even be a path to restoration. This is the part that shocked me when I first dug into it. So many people think one complaint, one hospital visit, or one bad family argument means your rights are gone forever. That is not always true. In many states, so-called red flag laws or extreme risk laws work through a court process. Some allow emergency action first, but then require a full hearing soon after, often within days or a few weeks. In other words, a temporary emergency step is not supposed to be the end of the story. Source. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Let me explain why this matters for seniors. Picture a family fight after dad forgets where he put the truck keys. Somebody panics. Somebody says, "Take all the guns now." Emotions run hot. In a real crisis, fast action may be needed, but outside voices often skip over due process. They talk like suspicion equals permanent loss. It usually does not work that way. Courts, hearings, evidence, and time limits matter. And if you never learn that, you may give up before the process even begins. Source. And here's the part almost nobody talks about. Federal law also contains a relief provision in 18 U.S.C. 925C. The Justice Department says the Attorney General may grant relief from certain federal firearm restrictions, and DOJ says it is developing a web-based application process for people seeking restoration of federal firearm rights. That does not mean every person qualifies. It does not erase state law, but it does mean the idea of once lost, always lost, is not always the full story. For some people, there may be a lawful road back. Source. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the community that gets these updates first, because one good legal update can save you from one very bad decision. Click subscribe right now. Fifth, moving into assisted living does not automatically erase your Second Amendment rights, but the contract and the facility rules can change what happens on the property. This is the forgotten senior gun right that hits families out of nowhere. 4, mom is moving, dad is downsizing, the kids are packing boxes. Then someone finds the locked handgun safe and says, well, that's over. Assisted living means no more rights. Not so fast. One senior care source explains that residents do not automatically lose Second Amendment rights just because of a change in living arrangement. But many assisted living facilities can legally prohibit firearms on the premises, and some states have strict storage rules or outright limits in certain facilities. Source. Most people think this issue is simple. It is not. There are really 3 layers. First, your general legal right to own a firearm. Second, your state's rules about guns in these settings. Third, the private policy of the facility itself. And those 3 layers do not always match. You might still lawfully own firearms, but not be allowed to keep or carry them in that specific building. That is a huge difference. Source. Here's a hypothetical example to explain this. Imagine Carol, age 74, moves into a retirement community after knee surgery. Her son tells everyone she has to get rid of her revolver now. But what if Carol's state allows firearm possession, And what really controls the situation is the facility's written no weapons policy. In that case, the issue is not that Carol lost all gun rights forever. The issue is that this property has rules she agreed to. That means the smart move is to read the contract before move-in day, ask direct questions, and make a safe plan for storage, transfer, or off-site keeping if needed. Source: don't make this mistake. Do not wait until the moving truck is in the driveway. That is when families panic and do sloppy things. They hand guns to the wrong person. They mix up gifts, storage, and transfers. They assume the law says one thing when the lease says another. The forgotten right here is the right to know the difference. Moving changes logistics. It does not automatically rewrite federal gun law. Laws change fast. Really fast. Subscribe now, because the next video is going to walk you through the exact questions to ask before you transfer, store, or inherit any firearm in your family. If you wait until there's a crisis, you're already behind. So here's the big takeaway. Getting older does not automatically cancel your gun rights. Your age alone is not a federal ban. Your Social Security check is not a federal ban. Your family heirlooms do not become untouchable just because they cross state lines in an inheritance. And even when problems do come up, process, paperwork, and state law matter more than rumor and fear. If this video helped you, subscribe right now and share it with one person in your family who needs to hear it. A son, a daughter, a spouse, or a friend. Because bad gun advice spreads fast, and seniors are often the first people pushed into giving up rights they still have. Final reminder, laws are different from state to state, and facts matter, so always check your local law or talk to a qualified attorney before you act.